All right. Good morning, everyone. It's February 8th, 2022, and this is the Law and Policy Committee meeting of the California Fair Political Practices Commission. Ms. Lincoln, would you call the roll?
Commissioner Baker. Here. Chair Matich.
Here. Proceed with item 1, that is public comment for items not on today's agenda. Do we have any public comment for things not on our agenda? Hearing and seeing none, we'll proceed to item 2, approval of the October 12th, 2021 committee minutes. Mr. Baker, do you have any edits or comments on the minutes?
I do not, and I move to approve.
Ms. Linker?
Commissioner Baker.
Aye.
Chair Matich.
Aye. Proceed to item 3. This is our legislative update, and we'll welcome to the table our senior FPPC Legislative Counsel, Ms. Nakano. Good morning.
Good morning, Chair Matich and Commissioner Baker. As of now, 4 bills have been introduced this year containing the Commission's priority proposals. 2 of them were introduced since the last Commission meeting last month. The first of those is AB 2172 by Assemblymember Cervantes. The bill is currently a spot bill, but it will be amended with the Commission's proposal to eliminate the dual paper filing requirement under the PRA. The second bill is SB 1483 by Assemblymember Glazer, relating to the Commission's new education program for individuals who have a low level of experience with the Political Reform Act and who commit violations with minimal public harm. This was referred to as the diversion program, but staff is considering alternative titles given feedback from the Commission last month. The Commission in a previous meeting had questions regarding the fee amount for participation in the education program. Staff is tentatively considering possibly $50 for SEI courses and $100 for all other courses. On AB 775 related.
Before you move on, can you just remind us what was staff's process and what's your rationale for setting those fee amounts?
For SEIs, these are the most simple courses. They require the least staff resources and the least amount of resources to update these programs. Additionally, staff looked at the current streamlined penalty amounts and scaled back from those to ensure that nothing would be, so that everything was semi-proportional. On AB 775 relating to automatic recurring contributions, staff sent a letter to Assemblymember Berman's office as well as the elections committees pursuant to the Commission's direction at the February Commission meeting. The letter reaffirms the Commission's support for the bill and the bill's goals generally and encourages the legislature to move forward with that legislation as soon as possible this year. On SB 921 by Senator Newman, which would create a state archive for state-level digital campaign ads, we've submitted a support letter for the bill, and we've also received some feedback from stakeholders, including some concerns about the deadlines for submission. Staff is continuing to work with stakeholders and the author's office on the bill, and I will keep this committee and the Commission updated on any developments.
Yeah, jump in there if we're going by bill. I did want to go back to just 775. The letters that you're referring to are the ones signed by Commissioner Chair Matich and myself on behalf of the Commission. Correct. To both the committee and the author. I just wanted to clarify that one.
Yes, correct.
Thank you. And then on, I think it's SB 925, Senator Newman's bill. Did I get the number right on that?
921.
921, thank you. When you mentioned stakeholders, can you say a little bit more about what we're identifying as stakeholders at this point?
Individuals, essentially committees, folks who would have to submit to the archive. Generally, people are concerned, I think, about the 24-hour deadline, kind of the burdens that would create. So that's generally who we're looking at.
So perhaps, I didn't know if that meant practitioners who do the filing and are either associations of professionals who do this. I'm just curious who we are identifying as stakeholders beyond the general public. I don't need names. I'm just kind of understanding a little bit more. They're people who actually are practitioners and do it.
I think that's correct.
Thank you.
On to other commission-related legislation. There are 9 other commission-related bills active this year, 6 of which were introduced after last month's commission meeting, so I will briefly go over those now. The first is AB 2528. This is by Assemblymember Bigelow. It requires an elected officer's statement, report, or document required pursuant to the Act that is not currently filed with the SOS to be filed with the SOS through their online filing and disclosure system, in addition to being filed with whoever else the statement, report, or document is currently filed with under the PRA, such as the elected officer's local filing officer or the commission.
Ask a question about that. So currently, I think we receive behest payment reports from members of the legislature, for example. Would this change that, and instead that would go to SOS?
It is in addition to. So the bill as written is quite broad. Any statement, report, or document filed under the PRA, if it's not currently with the SOS, it'll be filed with the SOS in addition to who it's currently filed with.
Okay. So in the case of behest payment report, just they'd have to file with their filing officer, with us, and with SOS.
Correct.
Okay.
I'll chime in on that as well. How much could this potentially cover local office holders, say at a county level or city council or school board level as well? How would they be affected by the bill as written?
I believe they'd all be affected. The bill is very broad, so it covers pretty much everything filed under the Act.
And currently now, depending on if they're local like that, they may not have some of their forms that they file locally that their local jurisdiction requires may not be coming to us or otherwise available electronically. That's what I understand. Potentially this bill could cover that.
That's right.
Okay. Is there actual bill language on that, or was this a spot one?
Yes, the bill is in print with this language.
Gotcha. Okay.
One final question. Is the obligation on the actual filer to submit their report with SOS, or is it the filing officer would transfer a copy? Whose obligation is it?
I'd have to take another look at the language. It's the filers, according to Mr. Bainbridge.
Okay. All right. Thank you.
Last one on this one, if I may. And these would just be questions as going forward as this bill may proceed. Be interesting to find out if that's been tried before. I don't expect to have this at your fingertips right now. And if they have bipartisan authors and where this might be going. I'm very intrigued by this one. It might be something that either at the full commission meeting or next law and policy, depending on the fate as it comes. You know, there's lots of bill deadlines and things. I might be interested in seeing if this is something we want to get behind. Sounds like it could be a great transparency improvement that would make sense. So I'll put those couple of points out there and appreciate you looking into it, and we'll hear back from you when you get a chance.
Thank you. I'll move on to the next one, AB 2544, currently just a spot bill. It's a PRA spot bill. However, based on previous conversations with the author's office, this will likely be amended to be outside of the PRA. SB 1352 by Senator Allen. This bill revises the contribution reporting requirement for contributions received before the 90-day pre-election period. So currently, candidates for elective state office must report contributions of $5,000 or more within 10 business days. If the contribution is received from a single source before the 90-day pre-election period. The bill would lower the threshold for purposes of reporting from $5,000 to $1,000 and would make the deadline for reporting 72 hours instead of 10 days. The bill would also extend these reporting requirements to committees primarily formed to support or oppose a candidate for elective state office. SB 1360 by Senator Umberg is similar to SB 752 by Senator Allen last year. The bill would require certain political advertisements to identify the top contributors without regard to any minimum contribution threshold. Currently, the minimum threshold for top contributors is set at $50,000. The bill would also make other changes to the disclosure requirements for political ads, including changes to the required form, content, and presentation of certain types of disclosures. This bill would also make
I apologize. I thought you might be
Please.
done on that one. I'll just wait for you. Thank you.
One more thing in this bill I'll mention. It would also make changes in the elections code relating to the initiative, referendum, and recall process, or particularly petitions, including by requiring a new disclosure statement relating to top funders.
Yep. Is this one sponsored by anyone? It sounds familiar to bills that we've seen before, sponsored by advocacy groups.
I believe California Clean Money campaign is sponsoring this one.
Okay, got it.
I just want to make sure, because you had mentioned it's similar to last year, but I just remember it as the issue ad bill. So when you're talking about SB 1360 and it says would require certain political advertising, are you talking about issue ads, or are you talking about what we consider to be political advertisements that, you know, advocate for or against particular?
That was another Allen bill, I believe that was 459, which had the lobbying reporting requirements and the issue ad requirements. This one was a separate Allen bill that was relating to advertisement disclosures and not the issue ad subject. Okay, two more, SB 1362 by Senator Melendez. This would require any person who makes payments to influence action of the Citizens Redistricting Commission totaling $1,000 or more in a calendar year to submit reports about those payments to the SOS. SB 1439 by Senator Glazer applies certain disqualification rules and contribution limitations to directly elected officials of local government agencies. These officials are currently exempt from the existing provisions that generally prohibit contributions to an official of an agency of more than $250 from any party, participant, or an agent of either, while certain proceedings are pending before the agency and for 3 months after a final decision. These local officials are also currently exempt from disqualification requirements for contributions received in the 12 months prior to the proceeding. The bill would eliminate these exemptions and apply these rules to directly elected local government officials. The bill also extends the amount of time that a party or participant is prohibited from making a contribution after the proceeding, from 3 months from the date of the final decision to 12 months from the date of the final decision. That concludes my updates today. I'd be happy to take any questions.
I had a couple questions on 1439. What agencies would enforce this prohibition? Would that be something that we would be enforcing?
It's the same as the current prohibition, so I believe it's us.
You identified what the fiscal impact would be for us on this expansion? I mean, conceptually, I certainly think this is good policy direction.
We have not determined the fiscal impact yet, but I will work with staff to determine that.
Thank you. Yes, great summary. Lots happened since the last time we connected with you about legislation. I believe you mentioned a bill by Senator Melendez regarding if there's advocacy for the Redistricting Commission. Is that traditionally in our jurisdiction, that particular bill?
They are considered, I believe, a state agency as a commission. They do have a conflict of interest code. I don't know, besides that, to what extent we regulated them, or to what extent we regulate them currently. I'd have to do a little bit more research as to how that affected.
Maybe another way as well is if the mechanism that the bill uses is an amendment to the PRA to include this regulation of the Redistricting Commission. Do you happen to know that? We can circle back when maybe at the full commission meeting or otherwise. That would be a question I'd be curious about, is if this is something that could potentially be in our purview to then have some oversight. Is that?
Yeah,
you might
fortunately have the bill language.
Okay.
And it is amending the Political Reform Act, and as I sort of suspected, I think this would be an extension of the lobbying rules. Anytime you see something like intended to the lobbying rules, I think that would come into play. And so I assume that's because Redistricting Commission was set up in such a way that our lobbying rules don't currently apply to them. And so folks can, for pay, go and advocate certain lines be drawn in certain ways without being subject to the same requirement, is what it seems like. And so this would improve the transparency.
I would think that's probably what was the impetus too, yeah. And which made me very curious if this is something that would be written in such a way it would be like our lobbying disclosure rules. That would be another one that kind of piques my interest, particularly if it has bipartisan support, and if we see how that one plays out. If there, I know that perhaps the next steps are is bills will be scheduled for committee. We'll see what makes a hearing and what doesn't make it out. And I always appreciate the questions that the chair has asked, good questions about how this might affect our bottom line and what our bandwidth would be. In concept, it's something that I would find very helpful, as we've just gone through this redistricting process. While we've learned, while it's close in time potentially to what people experienced instead of 10 years from now trying to change the rules, not having read the bill, I'd be curious, really curious of watching this one. That's where I'm going. And who might be participating as either stakeholders, sponsors, or bipartisan authors. Thank you.
Mr. Kano?
Nothing further today.
All right, thanks, Mr. Kano. Appreciate it.
Thank you.
Do we have any public comment on our legislative update? Hearing and seeing none, we'll proceed to our final item. That's discussion of items for our April 2022 committee meeting. I know, Mr. Kano, you'll be back with us, giving us an update on where things stand with the legislation. Commissioner Baker, anything you'd like?
I did, and I'm always cautious about either governing or rulemaking or agenda setting based on anecdotes that you read about in the newspaper, but we also don't want to be blind to news and information that is out there. There were two news stories that popped up in my mind in the last week or two that are not specific to Legislative Council and your position, Ms. Nakano, but just might be appropriate for either law and policy or the full commission. I welcome the chair's thought on that. One is this concept of bounties that consultants can get for what looks like advocacy without having to register as a lobbyist or comply with rules. This was a recent, I'm just going to say this was a recent article in the Sacramento Bee on March 2nd that really caught my attention, something I was not familiar with, and I would welcome an opportunity, perhaps in the full commission with the benefit of all commissioners, but again, the chair may have some great thoughts on that, to what's going on there. What do we know? What is the law? What appears to be the current practice? And we may even start having conversations about what we as a commission might want to do to address that is appropriate for us. Again, I welcome the chair's thoughts on that. And then more recently, very interesting commentary about transparency rules that apply to us as a commission, whether they're 1974 or more recent rules and amendments, both for my education as a commissioner as well as maybe the general public. And in that, I would welcome a briefing on that as well, and at least some further understanding. I'm happy to get specific. So I'm not just going on what I read in the newspapers, and there may be no appropriate action on our part, but those are two topics that I think might be worth visiting. Thank you.
I think with respect to the bounty article in the newspaper, it was referring to a particular section of I Cambridge can speak to this more authoritatively than me, but my understanding is we would change that issue, and so I think that's something that the commission as a whole could discuss for next year's package. But we did have a conversation about that. Really was an enlightening. And then with respect to the APA article, which I think was Richard Rios from the Olson, political lawyer, and then a lobbyist, I think was the other. That issue was litigated, as the article suggested, and that decision is available, and I think we can provide that to all the commissioners. I think that's helpful background. But in a nutshell, the act was written in such a way that that is what the court determined we were subject to, not the modern iteration of the APA. Mm-hmm. And I think the central reasoning for that, which we ought to pay a lot of attention to, is the need to maintain the independence of our agency. one of the critical aspects of the voters' intent in adopting the Political Reform Act. And if you were to take our agency and impose the entirety of the modern APA on it, the result would be that a political appointee who could be hired, replaced at any time within the executive branch would have to approve all of our regulations. I think that may give some pause to the public to learn that politicians could then veto the regulations. That's personally, having been familiar with the third DECA's opinion, I think it was the right decision, but certainly perhaps at a future meeting we can.
Yeah, I would welcome that. I don't think it's something that is of the same urgency of other points that we've raised. Certainly transparency is, but I would welcome that also for some institutional knowledge of commissioners. I'd be happy to read the opinion as well, and I'm very grateful for the chair's impression, but that would be important. If I may ask on the first one related to legislation, because as some folks who may be watching realize, there's deadlines by which bills have to be introduced for the next year, and yes, they happen. PRA changes can happen. Bills that aren't introduced by deadlines, some bills aren't subject to them. And I wonder, there's also spot bills that are in place. I would just appreciate a little bit better understanding, apart from just what was written in the article. Maybe we've looked at this issue before and come up with what are some potential solutions. So I would welcome both of those just at the appropriate time. I don't know that it would be rushing it onto the April agenda meeting. I know we'll have a lot going on, but perhaps before next fall when we develop our legislative package, because you never know, we have opportunities. So welcome your thoughts on that.
Yeah, I think that particular issue, the bounty reference, we do on our regulatory calendar already have some regulations related to lobbying activity. And so perhaps at that time, if staff could both clear for us, but on the regulations, what we're trying to address with those regulations, but then separately address the bounty issue and why we can't address that by regulation, what the legislative fix for that issue. So
thank you. Agreed. And there may be, some bills take multiple years, as we know. Hopefully we're not going to experience that with recurring contributions, and you start to lay the groundwork in the prior year as much as you can, and this will be a starting point for that, which I think would be good. Thank you. Those are all the right ideas I've got for the next agenda. Thank you.
Excellent. All right. Anything further, Mr. Cano, Ms. West, Mr. Bainbridge? All right. I will entertain a motion to adjourn.
Move to adjourn.
Second, Ms. Linker.
Commissioner Baker?
Aye.
Chair Manich?
Aye.
The motion passes.
All right. Thank you, everyone. We'll see you later in the